tinenge tichitanga ku commemorate 16 days of activism against gender-based violence. So what are we doing? We're just amplifying our voices. It's something that we're talking about, but we're just amplifying our voices. Taneta ne mirizhonga, taneta isusu. But what can we do as women? We also need to know, mirizhonga chacho, what are the forms? So she's going to be here. We also have entertainment guru, Dokas Moyo, who's amongst us, who is among us, and vachange vachizotipa entertainment. I'm sure many of you know kuti Dokas Moyo ndiyani, and we also have Mrs. Edith Mukwapasi, vachatipa keynote address, ndo vachatipa tsira ndi co-director veku Gnostics Academy. Allow me again to acknowledge the presence of our editor as Manica Post, Mrs. Wendy Matinde. She's also among us. And then we also have people that we have been working with. Good program ino ite pakashandwa panema organizations akasiyana who got together. Some wakauya ne funding, some wakauya ne jakasiyana. So Diamond FM ndo iri panapa, they're going to be covering the event, and we also have the Big Rock ndo vakatipa funding kuti program ino inge iripo vakatipa funding, and we also have Schweppes ndo vatipa ma drinks atukumwa nemvura. We also have funding from ZCDC. We have Empower Bank vatipa futi funding. We've got City of Mutare, Africa University, Manicaland State University of Applied Sciences, and my individuals akasiyana vatibatsira kuti program yedu iyenderere mberi. So once again, ngatizviemberere maoko for being able to be present pano. So ndichadaidzawo editor wedu Mrs. Wendy Matinde kuti vauye pamberi vatipewo ma welcome remarks. Maoko.
Ladies, Magadini, I hope you are looking so beautiful and makachena. Kana vanga vasina kukutaurira irigedza ndikudze. You are looking so beautiful. So good morning, ladies and gentlemen. My name is Wendy Matinde, and it is my great pleasure on behalf of the Manica Post to welcome you to this event. We are delighted to have you with us to participate in this special edition, in this special occasion, which is the inaugural edition of the Ladies Summer School. I thank everyone for coming, especially at such short notice. I know you are all very busy women, and it's difficult to take time off your busy schedules. That many of us have willingly traveled long distances to be here with us serves as a reminder to us all just how important what we are doing is. As a family newspaper, the Manica Post is committed to actively fight gender-based violence. To that end, we want all women, regardless of race, age, or circumstance, to achieve their full potential. Once we have an empowered woman who is financially independent and knowledgeable about the country's laws, we will be able to deal with gender-based violence ruthlessly and effectively. Our task, you and I, is to make that possible. The success of women is a goal that I know we all share. Together, let's turn it into reality. Our theme for this year's summer school is Fix Your Own Crown. The writing is on the wall. It is clear, ladies. No one is going to give us anything on a silver platter. We have to work hard to fight for our dreams. If it is a business that you want, you have to get up and start it today. If it is success in your current role, start pulling the long hours today. For today's deliberations, we are honored to have Tabitha Mwayera-Chikeya, a prominent lawyer, Dorcas Moyo, one of our greatest musicians of our time. We also have Carol Marufubu, former Miss Zimbabwe, and a guest speaker, Mrs. Mukwapasi, that I will then introduce later on. So prepare yourself to be challenged, excited, and inspired. As I hand over to our Director of Ceremonies once again, welcome to the Manica Post Ladies Summer School. I thank you.
Malko. Right. So nguwa iya yasvika yekuti tinyatse kuzwisisa zvakadzama maererano neMarriage Act and inheritance laws. So zvachaita is kana guest wedu apedza kutaura, I'm going to be taking questions and then guest wedu votibatsira kuti tinyatse kunzwisisa zvakazara maererano neMarriage Act. Tokumbira mu omberere Tabitha Mwayera. Maoko.
Makadini zvenyu. Yes. Whenever I'm presenting to women, I always like to be at the level ground because these issues affect you and they also affect me as well, right? So the moment Yatino Taura, you allow me to speak using both English and Shona so that we can better understand what we want to discuss about. Before I begin, I'm going to start by a story. We are all Zimbabweans, right? And we know our culture, is it? Our culture, pairorwa munhu chichaitika kudhara. Aibvisirwa pfuma nditi? Kudhara kwaimboitwa zvana kusenga bere zvakara nditi? So basically our Shona culture or even our Ndebele culture said whenever a woman wanted to be betrothed or to be married by a man, the man would come to the homestead and pay what is called lobola. And that was sufficient for there to be a marriage. And then fast forward, the white men came here. Zimbabwe was colonized. And during the process of colonization, we are also colonized in the way that we think. We are colonized also in the way that our culture is affected. Pakavapaiswa mutemo unonzi izvoni civil law and cultural or customary law, right? So which means when you are married either under civil law or general law, which is the white man's law in courts, or under customary law. That's where the confusion is now bred. Pakutizon isusu as the black people, as the African people, we no longer know what kind of marriage to contract into. And in order for there to be sanity, laws have to be put in place. But whenever a law is put into place, people might be advantaged or disadvantaged because the law will never be fair to everyone. So that's why in law we say law is law regardless of whether it is just or unjust. Law is law regardless of its moral content. Law is law regardless of whatever you might think is the right thing to be done. But whenever the legislators put in place laws, our duty is to obey the laws. And in obeying the laws, what we can now then do, if the law seems to be unjust to you, as lawyers, we now then try to help you to move around the situation and protect your own interests. So I think last year there was an uproar on the new marriage bill. By then it was a bill, but now it's an act. The difference between a bill and an act is that a bill is still in the process of being formulated into law. But once it's now an act, it means that the legislators as well as the president have passed it into law. So from the 16th of September this year, the Marriage Act now stands. So which means we now have new regulations regarding our marriage laws. But in order for us to understand the new regulations, we have to understand the previous regulations, right? So previously, we used to have broadly two types of marriage. Number one, the customary law marriage. Customary law marriage in Doya Yekuti, a person, like we said, would go to your homestead and then they'll pay the bride price. But after paying the bride price, you then go and register that marriage. Kunonzi kwaMjiti, anditi vana mai vedu, vana mbuya vedu, they used to go kwana Mjiti. Ndo muchato waifambira, the registered customary law marriage. This type of marriage allows polygamy. So which means the man can have as many wives as he can. And you cannot sue him for adultery damages. Because the law allows him to have many wives. But it's monogamous for the wife. The wife only has one husband. And the other type of law is the unregistered customary law union. It is almost similar to the registered customary law marriage, but different only in respect here, which it's not registered. So in terms of the law, it's not recognized as a marriage. And then I'll pose a question to the floor. How many of us vakabvisirwa pfuma? Anditi, wabvisirwa pfuma wobva watogumira ipapo? Varimo anditi? That's the widely contracted form of union here in Zimbabwe. Zvekuti unongobvisirwa hauendi kunoregister anyway, but uri kutozikanwa semuroora kumba kwawakadini kwawakaroorwa. But in terms of the law, it's not a marriage. If you are listening closely, I said unregistered customary law union. It's not a marriage. So previously, it was not recognized. And in the new Marriage Act, we want also to learn, is it now recognized as a marriage or not? So the unregistered customary law union was recognized for limited purposes. Only for the purposes of inheritance was it recognized as a marriage. So which means if you wanted to divorce your husband in court, your union was not recognized as a marriage. But the courts now devised a way you could maybe mashanda mese and it mawana zvinhu mese. And for the courts not to intervene, maybe you'll be dealt with unjustly. Skaya is on the dissolution of a customary law union, and it had its own modalities, but it wasn't dissolved as a marriage, but rather as a union, only for the purposes of assets which you would have gotten together. Then the other one, the most popular one, the chapter 5.11 yekudhara. Hatichatombotauri kuti kana muine muchato iwo hamuchatovhumidzi kuti muti I've got a chapter 5.11 marriage, because it was repealed when this other new Marriages Act came into place. So which means all other provisions in the chapter 5.11 are now at the mercy of the new Marriage Act. So the old Marriage Act used to say it's a monogamous marriage, one man, one woman. And you could sue for adultery damages if you found out that your husband was maybe having an affair with another woman. You had the right to sue for adultery damages. And if you thought you no longer wanted to be in the marriage and you wanted to divorce your husband, the Matrimonial Causes Act, which still exists, by the way, but it exists in consultation with the New Marriages Act. But it wasn't repealed. You know, the Matrimonial Causes Act. That Matrimonial Causes Act was used to then determine the rights of women and men upon dissolving their marriage. And in Zimbabwe, our marriages using the Marriages Act yekudhara, they are potentially out of community of property. Kana ndichiti potentially out of community of property, zvinoreva kuti izvoni, the court at face value says what is yours belongs to yours. What is mine belongs to me. What is his belongs to his. So contrary to the view yataita, I think vanhu vakaunda noti kana ndatochata muchato wangu wekukoti kana kuti we-white wedding, tava 50-50. That's a popular misconception that I have to make sure kuti vakadzi tinoenda tisina pfungwa idzodzo. Even during the old law, it was never a 50-50. It was his, hers, and theirs, which means the husband had to prove what was his. Zvaakatenga achiri ega musati maroorana ndezvake. Zvawakatenga uchiri wega usati waroorwa ndezvani? Ndezvako. And then per these principles, multiple factors then come into play. You then ask yourself, what was your contribution? Financially, socially, in the upkeep of the children? How did you contribute? So it's not automatically kuti zvanzi theirs, it's 50-50. The costs now determined based on each party's contribution. So which means, depending with the way that you argue in court, maybe you might have been given 20%. If you argue well and show your proof, maybe 60, 70, 50, 50, but it's never definite kuti 50-50. Mungatoti maenda kuma-lawyers, makaona lawyer rako azodzoka wapigwa 20%, and then you say, my lawyer did something. Or maybe you represented yourself, and then wapigwa 20%, you say, the court yakatengwa. That's not the case. It's never 50-50. 50-50 if you prove that you are entitled to 50%. So that was the old law, right? As regards my marriage types anga ariko. Then comes the new law. The New Marriages Act. A lot of uproar has come, right? Maybe before I even start to talk about the New Marriages Act, uproar yakaitwa iyo, as ladies, we misdirected our efforts in trying to argue against this new law. Before a law is put into place, there are consultations that are made, right? And then you are invited through the press. Kuti uyai mupe ma contributions enyu. If you don't make your contributions during that time, the people who would have contributed, their thoughts are then put into paper. And then it becomes law. So right now, the law is there. So what we have to do is to unpack it to you. You know what the law states. If you need to make amendments, you make amendments. In here, I'm talking to a mixed crowd, right? There are people who are married, people who are not married, people who are cohabiting, people who are in other arrangements, right? So I'm going to unpack the law as it is, not picking a side, but saying the law as it is. Iwewe ndo unozoita self introspection uona kuti izvoni wakandinakira here kana kuti hauna kundinakira. So the registered customary law marriage is still recognized in terms of the New Marriages Act, and it has not changed in any material respect. So which means that Ataura Kumashure applies to the registered customary law marriage in terms of the New Marriages Act. And then the unregistered customary law union, and we say that's the most commonly contracted type of union, and it's still not recognized in the New Marriages Act. It's not recognized as a marriage. In courts, if you have got that type of marriage. And your rights as regards the unregistered customary law union, they are limited to guardianship rights, custody rights, and rights upon the death of the spouse. Kananchiti guardianship rights and custody rights, and you still enjoy the same rights as someone who's married. You still enjoy the same rights of custody for your child as a woman who's in a chapter 5.11, the former chapter 5.11. It has not changed. But what is not clear in our act, because in my gray areas, akati one day, is kutizoni, in terms of inheritance, do we still recognize this union as a marriage or not? Because the law is silent. It only says kutizoni, the union contracted before the inception of the act should be registered within 3 months. And those contracted after inception of the new act should be registered within 12 months of inception of the marriage or of the union. So which means the law does not clarify to us what happens if you do not register the union. Does it still mean that we are still using the old provisions that we had before as regards unregistered customary law unions? We can never know until such a time when maybe someone approaches the court and then the gray areas are clarified using the courts. But as it stands, there is no clear provision as to what happens to the rights of women who are living under such unions. Saka zvorowa kuti izvoni muchishona vakadzi vanenge vaine michato yakadai hatizivi kuti marights kana kodzero dzamuri kupiwa nemutemo dzakamira sei. Dzakafanana nedzemunhu ari muregistered customary law marriage here, dzakafanana nedzemunhu ari civil law marriage here. It's not clear until you approach the courts. Or do you even have the rights at all? or since it's not recognized as a marriage in terms of the law, do you have any rights or not? Or you're just someone who's cohabiting? So, those are my marriages, my unregistered customary law union. And then comes the civil law marriage. The civil law marriage still says it's monogamous. One man and one woman. It's still monogamous in nature. And then number two, upon dissolution, we still use matrimonial causes. His, hers, and theirs. That's the provision which still stands and is still potentially out of community of property. However, rights of women in civil law marriages have been altered to an extent. With the inception of what I'm about to discuss right now, anonymous civil partnerships. And this Pakapinda Act, each bill APRO was on the civil partnerships. So a question might come, what is a civil partnership? Chimborichi. I think we need to understand this as women because this now affects especially women who are married under the civil law. Because for a woman who's in a registered customary law marriage, still it was potentially polygamous. So which means they have not a panacha change in the regime of their marriage. But in the regime of women who are married in civil law marriages, there has been a change, potentially, in their marriage types. And that's where a lot of people are missing it. A lot of people, I notice, Doni, Apana, I'll use a loose word, mistress, and it is not a mistress. The mistress is not entitled, other schools of thought, they're saying the mistress is not entitled to anything as a civil partner, right? Other schools of thought are saying, Kutizoni, the mistress now has got my powers, which are unmatched. So I think we need to understand what a civil partnership is so that we can now draw our conclusions. A civil partnership, according to the Act, makaenda pa internet, you'll find New Marriages Act on websites like Veritas or Zimli, and you'll read for yourself. But I'm going to read into your hearing Section 41 of the New Marriages Act is clear in what it terms a civil partnership. It says a civil partnership exists where a relationship between a woman and woman, one, are both over the age of 18. And it is. Number two, have lived together without being legally married. Number three, this is the Act, are not within the degrees of affinity as provided in Section 7. Kana chiti degrees of affinity tukuti panozobuda incest kana mine ukama and it. So you must not have had any relationship of buditsa incest kana uti your cousin, your brother, your father, ipo pa inonga receive for partnership for as long as it's proved kutijoni there is a relationship. And then having regard to all circumstances of their relationship, have a relationship as the couple living together on genuine domestic basis. And it yatopedza ku explain what a civil partnership is. Let me break it down to you in simple terms. Number one, pane pakanyorwa here kunzi the man should be married or not married. Pane pari kubuda here kunzi izvoni kana ari married, what type of marriage regime should he be in? There isn't, right? So which means a man who's in a civil marriage can be in a civil partnership as well. It's as simple as that. And it hapana parikunzi izvoni muchato wawinawo wakaita sei, makaenda kwamuzviti here, makaenda kukoti here, makanobvisirana pfuma here. As long as you're not legally married and you are in a relationship either with someone else who's not legally married or someone who's legally married, a civil partnership exists. And then number two, once they have lived together without being married, what is the duration here of living together? Fancy 2 months, 3 months, there's no duration, right? Which means it's up to the courts to then decide the duration of the relationship for them to say there's a civil partnership. So which means kana murumo wako, whether you're the one who's in a civil partnership, achuya kwa uri once every weekend, you might argue that it's a civil partnership. If he comes once fortnightly, you can argue and still have it one. How many of us have their husbands, Warima 5.11, former 5.11, who don't live together and see each other during weekends only? Avamwere. Apanere vaneva rumo vari diaspora, but they're still in a marriage. It's still a marriage, right? So, which means it can be argued, kuti duration, in as much as ari kumba kwake kwa angari, we were in a civil partnership because we were in a relationship. And whereas if a child is born out of the relationship, it strengthens the case to show that there is a civil partnership. I'm not here to sugarcoat anything, but to just say the law as it is. My provisions without stating this is the act. And it's in simple language, which everyone understands, right? And then, having regard to all circumstances of their relationship, have a relationship as a couple living together on genuine domestic purposes or basis. Other people might have flats being rented out for them. Others maybe a room. Maybe if the husband, the man is wealthy enough, and then the children of the house, they call him our dad, right? So which means they are living on genuine domestic basis. So the owners now, yava panemunu, aitiro application to show that they are not living on genuine domestic basis. Because this is the definition of a civil partnership, which is given by the law. And then, in trying to further understand what a civil partnership is, the court looks at duration of the relationship, the nature and extent of their common residence. So here we're not talking of people who meet casually, maybe at lodges or at hotels. These people will not be in a civil partnership because they don't have a common residence. But for as long as there is a common residence, so which means Zataiti chapter 5.1 could you could go and say the adultery damage is being claimed against you because you are also rubber stamping. You're rubber stamping that this is a civil partnership. So when they now want to dissolve, they'll say mapepa wakaunza ukoti kuya uchiti izoni unemurume wangu anditi. They're showing that civil partnership, right? And then a degree of mutual commitment to a shared life and care and support of the children, reputation of public aspects of the relationship. I'll also use a word which is potentially degrading to women, but because of lack of a better word, I'll say kachinji kacho, women who are in civil law marriages, they term these other women slave queens. And it slave queens because they rely on your husband's money. And it. But the law is saying here, for as long as she can prove that children were being taken care of, for as long as she can prove that she was being supported, she was in a civil partnership. That's the law as it is, without me adding anything. And it. So what then becomes a gray area is when does a civil partnership begin to exist upon its dissolution or from its inception? So the Act does not clarify kuti izvoni muka yatiri civil partnership inotangira papi kuexist. A school of thought might say, how can you give rise to something upon its dissolution and not acknowledge its existence? Zvinonetsa handiti? Tingazoti izvoni chinhu chavapo here because tavoda kuchiputsa kana kuti tofanira kutochi-acknowledge kubva chitoripo. The law is not clear. It only gives provisions upon the dissolution of the civil partnership. Which also brings another question. Does it then mean that adultery damages are now archaic or extinct? Because mutemo is regardless of whether the man is in a civil marriage or not, a civil partnership can exist. So does it mean that we can no longer sue for adultery damages? It still remains a gray area in our law because there is no clear provision telling us, do we still have that as part of our law or not? So, vangwachida umboita masamons pange makamboita ka koti yakadecide. Tinobva tatuya tichitoitawo maseminars kuti izvoni, do we still have adultery damages or not? But for me, adultery damages, they are now of a lesser nature since the law is now recognizing these people. And you know, what then bothers me is an unregistered customary law union is not recognized at law. But a civil partnership is recognized at law and with the same powers or rights and obligations as a woman under a civil law marriage. Which means upon dissolution, hatisi kuti izvoni tiri kushandisa customary law, we are using the general law, the Matrimonial Causes Act yandataura iyai. That's the one which is applied in dissolution of civil partnerships. And where it gets more scary is that upon dissolution, which, let me give you a practical example. Let's say I'm married, right? And I'm in a 5.11, former 5.11 marriage. My husband pairs adventure, he has a civil partner. And I'm a civil partner. We acquire properties during the existence of this civil partner. Right? The civil partner no longer wants to be in the relationship. She wants to dissolve the partnership. Mutemo kushanda is Matrimonial Causes Act. His, hers, and theirs. Which means potentially properties which I would have acquired during the subsistence of my marriage with my husband are now up for distribution. That's what the law says. And in trying to, where it even becomes more difficult, where, reading our same section 41 here, it says where a civil partner, right, is married under a civil law marriage, the court shall not take into account properties belonging to the other spouse. But where the properties are made to be part of the dissolution of this partnership, the spouse, which means me, I have to approach the courts and show cause why the properties should not be distributed. Saka munhu aenda kanoita zvaiita somewhere else, right? And then the properties, they are now subject to this dispute. The courts say, once they are subject to this dispute, the courts cannot determine whether they belong to me or to her and my husband without me coming to the court and saying, no, this property does not belong to the civil partnership. This burden of proof, is it easy? These properties belong to me and my husband. How easy is it? How many women are at the forefront when properties are acquired? That's only one, right? Most women ozongonzwa tatenga imba ku Greenside, tatenga imba ku Murambi, tatenga imba ku Chikanga, tatenga imba ku Hope House. Some of us, we do not even take time to even read the paperwork. We are just content sitting in the house and maybe putting new tiles, buying new furniture, upgrading the house, upgrading the lawns, kubvisa majurahouse, chitoti juraho ndeye kudhara, let's renovate our house, let's repaint the house. That's what we are good at. But when it comes to paperwork, I'll tell you the majority of women do not even know the type of ownership scheme that they are in. Do they have title deeds? Do they have a cession agreement? Is it fully paid at council or not? Is it more so has the husband even transferred from the previous owner's name into his name? Many women do not know that. So how then will you be able to convince a judge of the High Court that this property belongs to me and my husband only? You see, it then becomes difficult. But also in trying to understand why the law brought about the issue of civil partnerships, there are people who were married under the old 5.11 and then they separated, but never concluded their divorces, right? The man wants to move on, right? He finds another woman, but because there's still this marriage type, which is the divorce, and the vakadzi taitobatira kuti as long as ndine marriage certificate, hana zvanoita sei zvanondiita. So the law is trying to come in and protect these women who are potentially at a risk of losing out. Because warorwa nemurume anga akarora someone else. I've multiple clients who have come to me, vatuone vana vachiti zvoti takuda kuti murume uyu afinalize divorce yekumashure. But isina kufinalize, but vakutogara vese as a couple. And usually because the law favored the existence of this marriage certificate, it means kuti zvoni this woman azouyawo vanhu varambana but pachine marriage certificate could not benefit. So in trying to balance it out, it's now at a disadvantage of the women who have a marriage certificate, potentially. But if your husband is as clean as wool, as white as the raiment of Jesus Christ, then this law will not affect you in any way. But as long as potentially your husband can go out and say hi to another woman, then potentially you are in for it. Because the law says upon dissolution, and my gray areas are ripo. So then comes a question. Does it then mean could our marriages and marriage certificate, they are no longer important? No, the marriage certificate is still of great importance. The same rights afforded to women in the previous chapter 5.11 still remain the same. So for as long as you don't have a potential civil partner coming against your husband, then you are okay. But if potentially there is someone who might come, I'm trying to talk to us as women and trying to balance it out. I'm a woman as well. Married, I've got sisters. Some sisters who are not married. Anditi. So, mutemo toda kuti utibatsire tese. Because some women who are not married, they are disadvantaged as well by women. Vangu vakarorwa kudhara but vakarambana. And also there are other women, in as much as this man might falter. They might have, because tiri mu Africa, anditi. Pandatanga pepe andati our law yatingatina was customary law, which was potentially polygamous. And our husbands, our men, they are still potentially polygamous in nature. Which means, anokwasunga chitokuda nemoyo wese muine your marriage certificate and still find someone else and invest with that person. And after investing with that person, it's also not fair for you to benefit from another woman's investment. So as women, we must then come to a point where we say, as women, so that in my own sphere, I protect my interests. In your own sphere, you protect your own interests. So I think I'll just rush through issue year inheritance and then give a way forward on issue year new marriage act and how to protect our property rights. So in terms of inheritance, we've got broadly two types of inheritance. Pane inonzi testate inheritance and intestate inheritance. These are legal terms, but which can be simplified to mean testate is a testimony. Munakanzari kupa testimony, zvinonzi zvapupu, handiti. So which means you've got somewhere written, or someone who you told. Ndo inonzi izvoni testate, saka yava nyaya yei yema-wills, handiti. And intestate means inheritance without a will. So I'll start with the most controversial one, which is inheritance without a will. Most women suffer due to issue inheritance pasina will. So inheritance without a will the administration of my estates, evanhu vanongowashaika pasina will, they are administered depending on the type of marriage that you have. If you've got the civil marriage, which is the 5.11, old 5.11, number one, you are entitled to kunenon's matrimonial home. Matrimonial home, ndichazonyanisa kuexplain in detail what we mean at law as matrimonial home. Because at face value, you might think kuti ingori imba yako anditi, from the word matrimony. Saka imba yangu yomuchato, yandaigara nemurume wangu anditi. That's matrimonial home. And then they are also entitled to a child's share of the free residue of the estate. Inonzi child's share ndeyekuti izvona kana muine vana 4, you are now taken as the 5th child. So which means you are entitled to 1/5 of the remainder of the estate. And the patrukuti free residue of estate, we must also put or take into account issue yema duties which are paid to the state. So number one, from 100% of your estate, if your husband or yourself dies without leaving a will, number one, you pay 4% to the master. And you pay 5% to Zimra as estate duty. You pay 4% to the executor where estate. So whether Machaga, a professional executor, or maybe the surviving spouse or one of the children becomes the executor, they are entitled to 4%, which is executor's fee, which means 13% of the entire estate goes to my duties. Let's make it more realistic. Zimbabwe is hard, right? Things are difficult in Zimbabwe. You will be lucky if you've got one house. You buy one house, and it's proven, let's say it's not the matrimonial home, you're supposed to pay 13%. Sakana imba yako iri worth 100,000, already you have to look for 13,000. Ndopa mnona dzimba dzichitengeswa dzichi-auctioniwa because of these duties. They are quite hefty, but ndozvine zvitoripo kuti you have to pay those duties. So potentially you take out the 13% mune imba yenyu 1. Paimba 1 iyoyo wanza haizi matrimonial home yako. Pasara let's say 77%, and pasara 77% loosely. 87, right? 87% yasara. For 87%, you are entitled to 1/5 of that 87%. Which means essentially you might be potentially disinherited. And let's also bear in mind that children either born in matrimony or out of matrimony, they have the same rights. Ndrukuti izvoni, if my husband, neni, tine vana vedu, andika, and he goes outside and he has other children, those other children enjoy the same rights as my children. I'll give you a case yandinoti muzoverengawo mega munoiwana pazimli futi iri kutaura about zvevana izvozvozvo. In this case, they had one house. The house was said yanga isiri matrimonial home, handiti yanzi haizi matrimonial home. The same formula yandataura iya ndo yakaita sei, ndo yakashanda. They had 4 children born of their marriage, and had, I think, another 8 children born out of matrimony. So it's 8 plus 4 plus you, which means 13. Saka imba iye kana maimboita cross border muchienda ku South Africa, muchivaka imba iyoyo, for as long as you do not appear on the papers, the property ndeye mufi, handiti. Saka you are now entitled to 1/13 of that house. And then, pause it, Nambotara issue a matrimonial home. What is a matrimonial home, right? Many women think kuti izvoni kana makatenga imba mese nemurume, imba inonga ine value yakanyanya ndo matrimonial home. Yes, you can do that if there are not disputes. But mostly panofa munhu ma-disputes, they arise. Right? So when disputes arise, courts then have to interpret what is a matrimonial home. A matrimonial home is the house where you were staying prior the death of the deceased. And parikunzi prior, apana timeline, apana ma days, apana unzi 2 days, apana unzi 3 days, I'm going to give you a case law, yakaitika. Ndoro versus Ndoro, High Court of Harare, 198 of 2012. In this case, a woman was married, chapter 5.11 at that time. She was working in Norton. Whilst she was working in Norton, they had a house in Kadoma. Due to the hardships, I can commute every day from Kadoma to Norton. It's difficult, right? It's painful for you to commute like every day. So she opted to stay at company program. But this man had other children out of marriage. The children went and argued, this is not her